So we are live and on the record.
All right, thank you very much and good morning. Welcome to this morning's session of the Appeals Court on April 12th, 2022. My name is Jeffrey Kinder and I'm joined this morning by Justice Peter Sachs and Justice Catherine Hand. We will be the panel in this case, the only case that we're hearing via Zoom this morning. The case is 21P0360, John Doe 17388 versus the Sex Offender Registry Board and Counsel. Let me just remind you that the case is impounded. Counsel for the appellant, you may proceed when you're ready.
Good morning. May it please the court. Attorney Xiomara Hernandez for the plaintiff appellant John Doe. The Sex Offender Registry Board classified my client as a level 3 sex offender. I'm here today to request that this court either lower my client's classification level or remand the case back to the board for another hearing. First, I would argue that the hearing examiner erroneously denied my client's motion for expert funds. As you'll see in the record, my client, about 3 months before the classification hearing, was diagnosed with antisocial personality disorder. This diagnosis placed focus on my client's mental condition. And because of this, I would assert that the board would have benefited from having an expert testify at the classification hearing and submit a report indicating what impact, if any, my client's diagnosis and possible treatment for this disorder would have on his risk of reoffending or dangerousness. And because of this, I would assert that the hearing examiner committed an error and that this court should remand it back to the to the board for another classification hearing.
Is there anything?
Sorry, go ahead.
No, go ahead, Judge Sachs.
There was no indication that your client was in treatment for this personality disorder, at least in the motion for funds that I saw. Is that correct?
Yeah, there's nothing in the record indicating that he was in treatment. What happened was he was diagnosed about 3 months prior to the classification hearing. And the hearing counsel only knew about it about, I think, a few days prior to the classification hearing. And that's why she filed the motion for funds late.
But was there any indication that he was planning to get treatment and that if he got treatment, he might pose less of a risk of reoffense and degree of dangerousness? I mean, I didn't even see that asserted in the motion by the attorney, never mind an affidavit from your client or from a potential expert.
There was nothing in the record indicating that he was planning to get treatment. You're correct, but just from talking, I mean, this isn't part of the record, but from talking to hearing counsel and my client, it looked like that was the plan. Again, there's nothing in the record concerning it, but had the hearing examiner at least allowed a motion to continue so that the hearing counsel could have maybe established that more and put it in the record, but it was just denied and, it wasn't continued and there was no the hearing examiner did not allow her funds to hire an expert. I mean, I would say that at least it should have been allowed so that somebody could have examined my client and determined that with treatment, whether or not his risk to reoffend would decrease or his dangerousness would decrease, but he was denied that right. So that's what I would assert.
He could do that today, couldn't he?
I'm sorry?
He could do that today, couldn't he? I think it's been 3 years since the hearing. He could seek reclassification, and if he had a better case for expert funds.
Well, he was actually incarcerated during the time of the hearing, and I believe his release date is sometime in 2022. He could have recently been released, I'm not sure. So that if I'm not incorrect, the time starts either 3 years from the classification hearings or 3 years from the last incarceration, which would have been, he's not out. Either he's out or he's about to get out. So it hasn't been 3 years since his last incarceration. So he wouldn't qualify to apply for a motion for reclass at this point. He would have to wait 3 years after he's released from incarceration. Any further questions regarding this issue? And I additionally, I'm sorry, Justice Kinder. I think you're muted.
Doesn't a diagnosis of antisocial personality disorder by definition suggest an increased rate of recidivism?
So yeah, if you read the regulations and many factors within them, they do indicate that if a person is diagnosed with that, but it doesn't indicate if they're diagnosed but then treated for it, if it would decrease a person's risk of reoffending or dangerousness. So I would assert that an expert should have been able to examine my client and determine that if he gets treated for that condition, if his risk to reoffend were to lower or if his dangerousness were to decrease as a result of that. And again, the hearing examiner denied my client of that right. I would also argue that
if we were to agree with you on that point, would that mean that every defendant or petitioner who had an antisocial personality disorder would be entitled to expert assistance on that question?
I would say yes. I would say yes. And I would also argue that the hearing examiner erred by failing to give full weight to risk mitigating factor 32, which is sex offender treatment. The hearing examiner found, quote, because of the short duration of treatment, he refused to give this risk mitigating factor full weight. As you'll see, my client was in treatment. He began 2018 while he was in Gardner, and he continued treatment when he transferred to the Mass Treatment Center. His participation was labeled as acceptable. He was active during his treatment, and he attended consistently, and he demonstrated an understanding of the materials. And also, if you
I'm sorry to interrupt you, but I apologize for interrupting. Was the treatment complete at the time the classification hearing was held?
It was not, no. He had started about a year prior. I don't even think there's any indication that he even finished the first part of the treatment. But nonetheless, he was in treatment. And what this factor indicates is that if somebody's actively in treatment, which my client was, this factor should at least be given the threshold application. If you look at factor 32, section A2, which is currently participating in treatment, there's no indication that lower weight should be given if a person isn't an offender, has only been in treatment for a short period of time.
Could the hearing examiner take into account the fact that there were something like, if my counting is correct, 9 years of incarceration that preceded your client's starting his sex offender treatment, and that the sex offender treatment started close to the time that the reclassification hearing was being held?
Well, there's nothing in the factor itself that would indicate that the hearing examiner has this ability to give it decreased weight because of that. I mean, there's other language in the factor that says when they're able to give decreased weight. For instance, if a person's in denial of committing the index crime, they could give decreased weight because of that. But there's nothing indicating that if an offender has been in treatment for a short period of time, that they're able to give a decreased weight because of that. And I would also assert that the hearing examiner erred by failing to give full risk mitigating weight to factor 34, which is stability in the community. Here, the hearing examiner found as follows. Because of his participation in programs potentially useful towards future stability is speculative given his current incarceration. So basically, the hearing examiner is saying that because my client is incarcerated, my client will, or any offender who is incarcerated during the classification hearing, will never be able to get full weight for this risk mitigating factor. And that result is unfair. My client did not choose when to have the classification hearing. It was the board. The board chose to have it while my client was incarcerated. So while he was incarcerated, he was very active in programming. He was involved in sex offender treatment. He was involved in many, many programs. I don't have the full list, but I know he was involved in I know with alcohol and substance abuse program and many other ones where he received certificates of completion for completing those programs. So I think the result is unfair to say because he is incarcerated, he doesn't qualify, because everything will be speculative, right? Because you're incarcerated. So it'll be speculative what's going to happen in the future. But the way my client was behaving at that moment in time was, somebody who was active in programming. And so because of that, I would assert that the hearing examiner erred by failing to give this factor full risk mitigating weight. And lastly, I would argue that the board failed to prove by clear and convincing evidence that my client poses a high risk of reoffending After he's released from probation, after he's released from incarceration, he'll be on probation for 10 years. You'll see that he committed his index crime many years ago. He was 29 years old and he was 40 years old at the time of the classification hearing. He was involved at least for a year in sex offender treatment. He does have the support of his mom, and there's indication that his, I believe, teenage daughter was visiting at the time. He was stable at the time in terms of his behavior while incarcerated. And he's had many years of sobriety, in part due because of the incarceration, but also because of his treatment and programming and substance abuse while he was incarcerated. And if there's no further questions, I'll submit it on the brief.
All right, very well. I see no further questions. Thank you for your argument.
Thank
Mr.
you.
Chennai, whenever you're ready.
If it pleases the court, Your Honors, David Chennai for the board. I want to start by thanking you for allowing me to do this by Zoom. And it's helpful for me at this point. Hopefully by next month, I'll be back in the court. The issue about the expert is that really an expert is designed to talk about an individual's, to assist a hearing examiner in helping to understand an individual's current risk and danger based on some type of characteristic that this offender has. The motion itself was designed to discuss, to assist the hearing examiner on a future risk and danger based on getting treatment and remission, which again is speculative at this time. So the board would state that the hearing examiner properly denied that motion for expert funds. As for the—
Could I interrupt
Sure.
and ask, does it matter that the board did not apply factor one here?
I think that it does matter in the sense that if factor one were applied, then I would think that applied negatively based on this condition, antisocial personality disorder, and that an expert wasn't given, I think that would have been error. But the hearing examiner made it clear that the antisocial personality isn't contemplated by factor one. It's contemplated by other factors, and therefore he didn't apply factor one to this case. But I've had cases where—
No, I see. I'm sorry to interrupt again, but you said the hearing examiner recognized that this factor was, or that this disorder was recognized by other factors. I see references in other factors to antisocial behavior, but is that necessarily the same as antisocial personality disorder? I mean, antisocial can be used in a number of senses, I suppose, and the technical sense in which it's used in the term antisocial personality disorder doesn't necessarily match up to the way it's used a little bit more colloquially, perhaps, in some of the other factors.
Well, I know there's a difference in the wording between antisocial personality and antisocial personality disorder. And personally, I don't know the difference between the two of them or what that would incur. If someone has an antisocial personality disorder, it doesn't change the motion itself. The motion for expert funds begins, again, the motion for expert funds didn't delineate that separation of wording also. So the hearing examiner, again, used the antisocial personality as, again, in risk elevating factors such as factor 10, factor 12, the factors that have antisocial personality components to it. So I guess the easy answer would be that because mental abnormality wasn't applied, this mental health condition wasn't a negative factor as to mental abnormality, and therefore that strengthens the hearing examiner's decision not to grant expert funds in this matter. I think when you have a mental abnormality under factor one, you're discussing mental conditions that would require, if asked, a hearing examiner to have assistance from professionals as to the impact of that type of mental abnormality, which again, under factor one is more compulsive. I think it actually specifies that the mental abnormality is compulsive in nature, and therefore an assistance would be helpful in those circumstances. And I think DOE 89230 specifically says factor one is a factor where an individual where assistance by a professional would be helpful for a hearing examiner to understand the applicability of it based on the condition presented by that offender. Unless there's other questions on the motion for expert funds, I think the other factors are pretty self-explanatory. Factor 32, for instance, the hearing examiner gave weight to it. He gave moderate weight. But again, the individual, and it's a common sense approach, if you've completed treatment under the factor, you're going to get more credit than if you're just participating in treatment. This individual was in the very beginning stages of treatment, and the hearing examiner gave them moderate weight for the treatment, for essentially being in treatment. Again, the hearing examiner gave moderate weight to the future stability in the community, even though the factor is about current stability. And again, he's been in prison for the last 10 years, but the hearing examiner acknowledged that he's been doing well in prison in his programming and gave him credit for that, gave him moderate weight for that. But again, we don't know when he's released if that's going to carry over. And again, unless the court has other questions, I'd be more than happy to rest on my brief on these issues.
One question, does the statute still require that offenders who are about to be released or are going to be released in some kind of near-term period be classified before they're released?
It still requires they be classified before they're released. Case law has changed some of the requirements. For instance, if an individual like this individual, if we had classified this individual, say 10 years ago or 11 or 9 years ago.
Yeah, you can't classify someone too long before they're released because there's too much potential for change. I remember a case saying that.
Right. I think that was 083, which I had argued. I think the case law also is clear that reclassifications, like even in the incarceration status, if an individual is not put in that category where they have to, they can have a rehearing, so everything is held up until their release time and they're given a chance to have further hearing on the issue, they're eligible for reclassifications every 3 years while incarcerated. That's changing in the sense that the board is weeding out individuals who have been previously classified while incarcerated and moving them to, I'm trying to remember the word they're using, but it's a status where they're not actually being disseminated on until closer in release date and they've had their ability to give additional information. So we're trying to clean that up. The case law has made it clear that we no longer are using the release date as the date where the next reclassification occurs. The individuals are allowed reclassification 3 years from their final classification. In this case,
what I was getting at with the question of whether reclassification needs to occur somewhere close to the time of release is Attorney Hernandez's argument that it's unfair to deny incarcerated offenders the benefits of Factor 32. And I'm wondering whether it's relevant to that issue that the statute requires incarcerated offenders to be classified while they're incarcerated. So in a sense, the statute
oh, okay, I see the argument.
precludes them or puts them at a disadvantage in terms of getting credit for Factor 32.
The case law has specifically said over the years that the board is required to classify individuals prior to release whenever possible, and that it may have a negative impact on their ability to show current stability in the community. But the court has said that that is not that does not prevent the board from going forward.
What case is that? Is that a published decision?
I believe so, and I think it dates back to the probably around 2014. I don't know the case offhand, but I do know there is case law on that issue. But there has been recently pushback in the courts about, and I've had this issue raised in front of this appeals court a couple of times about the issue that Attorney Hernandez is raising about whether or not somebody could get credit for community stability while they're incarcerated. And the argument to that is in this case, you can see that the hearing examiner did give him credit. I don't think you can get full credit for future community, but you can get credit for what you've done while you're incarcerated. And this individual got moderate credit for stability in the community, and based on the fact that he's done the programming, all that's left to be seen is how he incorporates that into his situation after he's released. So I don't think the hearing examiner abused his discretion. I thought the hearing examiner was generous in this area to make sure that he got some credit for what he was doing while he was incarcerated. But yes, there is case law that says that because the board has to classify prior to release, that factor 34 and factor 33 can be negatively affected, but that's unfortunately a byproduct of the statute.
And where is it in the statute that says offenders need to be classified prior to release?
I want to say it's either 178D, and I know it's not in 178K. I believe it's either D or E.
Okay.
Unless there's further questions, the board would be willing to rest on its brief.
I see none, Mr. Shanai. Thank you for your arguments. Thank you both.
Thank you, Your Honor.
Conclude our Zoom session for today.